Julius Kim, a defense attorney here in Milwaukee, has been a large part of our coverage as well in the evenings. A legal expert joining us now via Skype. Julius, I'll just start with the basic question. Your reaction to the guilty on all 76 counts verdict?
The verdicts really probably didn't come as a surprise to everyone based upon what we've seen, the evidence that was presented, and the lack of a strong case by Mr. Brooks. So I think that the verdicts aren't a surprise. I think that this case has been a tremendous test, not only for the prosecution, just in coordinating the sheer volume of witnesses and evidence in this case, but it was also a test for the judge. Certainly, Mr. Brooks was testing her patience, testing her judicial acumen to make sure that she protects the record in this particular case. But the case was also a test for the entire criminal justice system, because obviously this case was unusual. It was not like any other. There were a lot of obstacles in the way, but in the end, I think that justice was done and justice was served, and I hope that the Waukesha community and all of southeastern Wisconsin can start to move forward a little bit, and that this contributes to the healing process now that there have been verdicts in this case.
Julius, we're going to bring in Brian Paulson, who joins us this morning. Your reaction and questions also for Julius.
Well, one of the things that stands out to me is, Julius, throughout this trial, we obviously saw the judge seemingly bending over backwards to give the defendant the opportunity to be in the courtroom, the opportunity to be asked the same questions over and over again. And it would seem that that was an effort to avoid any concerns on appeal, maybe a potential mistrial. Over the course of these 17 days, did you see anything that might raise questions or concerns that Brooks might have some sort of an avenue on appeal, which would be the one thing I guess people have left to wonder about?
Yeah, that's a good question. Judge Darrell did a fantastic job of managing this trial, and I think a lot of what we saw in terms of her being patient and being somewhat lenient with Mr. Brooks in terms of his outbursts, et cetera, was not only her trying to protect the record in the case, but I also think Judge Darrell just wanted to have Mr. Brooks present in the courtroom if at all possible, recognize the situation he was under, and she knows that it's always best to have a defendant in the courtroom at his or her own trial. Now, as to an appeal, I think that the record during the entire case was actually pretty tight, pretty solid. Judge Darrell did a very good job of protecting the record, explaining her decisions along the way. If the way I look at it, if there's any questions that still kind of linger out there, one question might be the decision at the very outset of the case as to whether Mr. Brooks was not competent to stand trial. I think that everyone can agree, and the Court of Appeals will also find that he was competent to stand trial, but whether he was competent to represent himself. And Wisconsin has an additional standard with regards to people representing themselves. And there was no separate evaluation that was done on Mr. Brooks to make that determination. Judge Darrell relied on some evaluations that were done for essentially an insanity, potential insanity defense, and just anecdotal evidence of Mr. Brooks' prior counsel. An examination doesn't have to be done for that particular purpose, but because it wasn't done, that's going to leave some questions. I think also just Mr. Brooks' own antics, once it became clear that this trial was going to go forward, and with him taking off his shirt and acting out, made people start to wonder while the case was going on whether he is in fact competent to represent himself. So that might be one lingering issue that may still have to be answered down the line.